Turn Wi-Fi back on.
Are you gonna keep them in the waiting room?
Yes, I'm gonna, you want me, let me take them out so you can see how it is, and then I can always put them back in the waiting room. All right, everyone, just give me a moment while I get us set up. I don't think anybody expected rain this morning, but we got it. Would you show video, please? And then, Brenda, there was this long train. Because I mean, the best time for there to be a train is during morning rush hour. I can't think of a better time other than when people are trying to get home. All right, and when you all get a chance, could you bring out Mr. Hayek's client, please?
Please tell me.
Everyone, I'm going to call the docket. You need to make sure that you let me know you are here. If you're on the front row, sitting on the front row, that signifies that you were late for court. So if you don't want me to think you're late for court, you may not want to sit on the front row. Brenda, you know, in church, when you come in, they always make people come to the front row, whether you're late or not. So. All right. Chadrick Walker is in custody. Joshua Carroll. D'Angelo Robinson. Thank you. Michael Teo is in custody. Mark Ivy. Julius Clayton. Jose Lozano. Thank you. Charles Garley. Alvin Calvo. Caitlin Martinez. Caleb Coleman Lee. Jessica Medina. Damon Lloyd. Anthony Villarreal. Robert Trevino. Nicholas Herrera. Emmanuel Davila. Amber Grant. Pedro Rodriguez. And if there is a Sari, or is that Jerry Jordan, your case has been closed. It was dismissed. Cameron Salazar. Oh, Cameron Salazar was closed as well. All right, thank you. So it's been dismissed. Okay. All right, if there's a Cameron Salazar here, your case has been dismissed. Christopher Rodriguez. Robert Carter. Okay. Sean Branch and Nicholas Candiff, Justin Purry, Quentin Buto are in custody. Curtis Williams. Mariah Rodriguez. Curtis Williams. Thank you. Anthony Villarreal. Thank you. Shane Fox, Jose Castañon, Sade Lockhart, Justin Montemayor, Raymond Longoria, Anthony Bennett, Jacqueline Wells are all in custody. Janelia's crew is in custody. Vivian Ingo.
Present, Your Honor.
Thank you. Kayla Connor. Kayla Connor. Jacob Moya, Joe Lopez, Alfredo Hernandez. All right, is there anyone who's here whose name was not called? What's your name? Edward Castillo. Who's your attorney?
I'm here for him, Judge. I'm stepping in for him today.
All right, thank you. Just have a seat. I'm sorry, what? Who is your attorney? All right, just have a seat. We're going to get with you. All right, so everyone, here are the rules of the court. I try to keep the center of the court as least congested as possible. You will see that there are files to my right. There will be files to my left. On this side of the room is usually a criminal trial division. On this side is family violence. We're doing a closing argument for a jury trial. So we're going to take that up first. So everyone will confer, not in the courtroom as of this moment. We're going to see if all the jurors are here. If they're here, we're going to start up. But do not approach the court unless you've conferred with the state. If the state is able to give you an offer, you need to present that offer and confer with your client. Then, once you've done all of those things, you can approach the clerk, ask the clerk to place the file, signifying that you're ready to speak with the court. Once the clerk has placed the file here, have a seat. We will go in order of appearance. And it's the same thing with the state. Once you place your file down, they will call you when they are ready for you. They're going to go in an order of appearance. First will be first, last will be last. If you have someone who is in custody, we are not going to bring them out right now because, again, we're doing closing arguments. But once you've requested your client to come from the back, do not leave. If your client needs an interpreter and that interpreter is requested, do not leave because there's a shortage of interpreters. And I don't want the interpreter to come down and then we don't have all the parties ready. All right. So today is Monday. It's raining outside. This is the cold weather that everybody asked for. So I don't want to hear anybody saying it's too cold because just remember the 100-degree weather we had. So it's going to be a great day. Everyone put some patience in your pocket. And we're currently alive. How can it get any better? All right. So can we check to see if all the jurors are here? All right. Thank you.
Your Honor, may we approach, please?
Yes. Where are these witnesses? Like where are they? Yeah. Are they here right now?
Are they here right now? They're out of town.
Oh, no, we're proceeding. Yeah. Everybody rested and closed.
Took care of that problem.
Yes. All right.
We also have more of a plea of mercy.
Oh, if he wants to do closing argument and represent himself, then he can represent himself, but they can't be I'm doing closing argument and then he's doing it. Either he's going to represent himself in closing argument or he's not.
Okay. Did you hear that?
So you understand, Mr. Morales? Well, no, either you will represent yourself as your attorney in closing argument, or either your attorney will do closing argument. There is not a bifurcation of duties. You understand? All right.
That's it, Your Honor. Thank you.
All right. Thank you.
I'm just on the charge, Judge. I think still was the page about the defendant testifying. Probably that date is you can see taken.
Oh, thank you. Let me see.
It just makes me super wild.
No, I don't see it. Do you see it, Brenna? Yes.
Okay.
Yes. All right. You're welcome. No problem.
Yes.
Brenda, this chair is extremely high. I think it's like either that or I'm getting, it feels very different. Either that or I'm getting taller. Well, I have rain boots on. Okay, all right. We'll see if that's the issue. Huh? No, I mean, this is, unless they come by, I didn't ask them to change the chair. I just asked them to fix the AC. It's sort of like as an attorney, when you had a brief to write, the house, that's when the house would be sparkling clean because you would find everything but to do that. So I guess since I asked them to fix the AC, they're like, oh, we're going to give her a different chair. Yes.
You're closer to the AC. Oh, you guys killed yours.
All right, thank you.
I don't do anything.
All right, we're missing one juror.
Oh, we're missing a juror.
Okay, thanks. All right, then everyone, we're missing one juror. So the attorneys who have people on bond, please feel free to confer. But hopefully that juror is coming in shortly.
I have no idea.
Yeah.
Do you know if Ryan's coming?
But have you ever heard of Fluffy's Barbecue?
I don't know now.
Some new place.
The baby.
No. I mean, should barbecue make you feel healthy? Yeah, I don't know about that. Caroline, can you check to see the person over here? Raymond Zamora, is he really supposed to be on the document? Raymond Zamora, can you come forward, please? That's a win-win. All right, if you'll give your information to the clerk, we're going to see if you're supposed to be here or not.
Is there Kayla Connor?
Then the other person. Edward Castillo, can you come forward, please?
Did you entertain a plea of guilty now?
Oh, think on that. Give me a second.
All right. Yes, so his case is. Yes, so his case hasn't been indicted, but if you ever want it placed on the docket pre-indictment, you just need to contact the court and it'll be placed on the docket. Yes. Yes, he's excused. You can let your bondsman know that you appeared in court today. You're welcome.
Yes. Yeah, where is that? Where's the scholar? Okay, I'll go to him.
Um,
Thank you. Ah.
All right, let's bring them in. All right, the court is calling 2019 CR 9698, State of Texas versus Mario Morales. Could I have parties announced for the record for the state,
Michael Villarreal, Catherine Polly for the state.
for the defense?
Anton Hager for Mario Morales.
All right, are both parties ready to proceed with closing argument? State,
Yes, Your Honor.
defense?
Yes, Your Honor.
All right, and my understanding, each party is requesting 30 minutes?
Up to 30.
Okay.
And Judge, I don't know if we put it on the record last time. I know we had a bench conference and nobody had any objections to the charge, and it just went on the record. The state had no objections to the charge.
All right. Defense, any objection to the charge?
I'm gonna say Fence has no objections to the charge. Right?
All right, thank you. All right, what time announcements are you all requesting?
State's requesting 30 minutes.
No, I mean, do you want me to
want
give you a
10 minutes or
warning?
something?
Can you, Catherine's gonna use 10 minutes. So when she's used 10 minutes, will you let her know?
Yes.
And then when I have 5 minutes remaining, will you let me know?
All right, and Mr. Hyatt?
It sounds great. So.
All right, thank you. We're ready.
For the jury.
All right, everyone, please be seated. So this is also my morning docket. So this has absolutely nothing to do with this case. I know you all are used to there not being an audience here, but it's for other cases that I have, and it's in no way related to this case. All right, so what I'm going to do is I'm going to read to you the charge of the court. You will be given a copy of this when you go back to begin your deliberations. Charge of the court. The defendant, Mario Morales, stands charged by indictment with the offense of continuous sexual abuse of a young child alleged to have been committed on or about the 15th day of September 2011 through the 15th day of January 2014 in Bexar County, Texas. To this offense, the defendant has pleaded not guilty. 1, our law provides that a person commits the offense of continuous sexual abuse of a young child if during a period that is 30 or more days in duration, the person commits 2 or more acts of sexual abuse, and at the time of the commission of each of the acts of sexual abuse, the actor is 17 years of age or older and the victim is a child younger than 14 years of age. An act of sexual abuse means any act that is in violation of one or more of the following penal laws: aggravated sexual assault of a child and indecency with a child by sexual contact. Child means a person younger than 17 years of age. 3, our law provides that a person commits the offense of aggravated sexual assault of a child if he intentionally or knowingly causes the anus of a child to contact the sexual organ of another person, including the actor, or causes the mouth of a child to contact the sexual organ of another person, including the actor, or causes the penetration of the sexual organ of a child by any means, and the child is younger than 14 years of age at the time of the offense. 4, our law provides that a person commits the offense of indecency with a child by sexual contact if, with a child younger than 17 years of age, the person engages in sexual contact with the child or causes the child to engage in sexual contact. Sexual contact means any touching by a person, including touching through clothing, of any part of the genitals of a child with intent to arouse or gratify the sexual desire of any person. 5, a person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 6, our law provides that the time of the offense must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. The phrase on or about means that the state is not required to prove that the alleged offense happened on that exact date. There is no limitation period for the offenses of continuous sexual abuse of a young child, aggravated sexual assault of a child, or indecency with a child. Therefore, it is sufficient if the state proves that the offense charged herein, whether it be continuous sexual abuse of a young child, or aggravated sexual assault of a child, or indecency with a child, was committed sometime before August 29, 2019, which is the date the indictment was filed. In order to find the defendant guilty of the offense of continuous sexual abuse of a young child as charged in the indictment, you are not required to agree unanimously on which specific acts of sexual abuse were committed by the defendant or the exact date when those acts were committed. However, in order to find the defendant guilty of the offense of continuous sexual abuse of a young child as charged in the indictment, you must agree unanimously that the defendant, during a period that is 30 or more days in duration, committed 2 or more acts of sexual abuse. 8, now, if you find from the evidence beyond a reasonable doubt that in Bexar County, Texas, the defendant, Mario Morales, did then and there during a period that was 30 days or more, if you find from the evidence beyond a reasonable doubt that in Bexar County, Texas, the defendant, Mario Morales, did then and there during a period that was 30 or more days in duration, to wit, from on or about the 15th day of September 2011 through the 15th day of January 2014, when Mario Morales was 17 years of age or older, commit 2 or more acts of sexual abuse against a child younger than 14 years of age, namely, 1, Mario Morales did intentionally or knowingly cause the male sexual organ of Mario Morales to contact the anus of Sandy Sanchez, a child who was younger than 14 years. 2, Mario Morales did intentionally or knowingly cause the male sexual organ of Mario Morales to contact the mouth of Sandy Sanchez, a child who was younger than 14 years. 3, Mario Morales did intentionally or knowingly cause the penetration of the female sexual organ of Sandy Sanchez, a child who was younger than 14 years, by Mario Morales's finger. 4, Mario Morales did intentionally or knowingly engage in sexual contact with Sandy Sanchez, a female child younger than 14 years, by touching part of the genitals of Sandy Sanchez with the intent to arouse or gratify the sexual desire of any person, then you will find the defendant guilty of the offense of continuous sexual abuse of a young child as charged in the indictment, and do not consider any of the lesser included offenses as instructed in paragraphs 9 through 12 of this charge. If you do not find beyond a reasonable doubt, or if you have a reasonable doubt thereof, or if you are unable to agree, you will next consider whether the defendant is guilty of an offense that is a lesser included offense of continuous sexual abuse of a young child as charged in the indictment. 9, you are instructed that if you consider any of the lesser included offenses as instructed herein in paragraphs 10 through 12, your verdict on that lesser included offense, if any, must be unanimous about which specific instance of sexual misconduct, if any, constituted the commission of that lesser included offense as instructed. 10, now, if you unanimously find from evidence beyond a reasonable doubt that on or about September 15, 2011 in Bexar County, Texas, the defendant, Mario Morales, did intentionally or knowingly cause the male sexual organ of Mario Morales to contact the anus of Sandy Sanchez, a child who was younger than 14 years, then you will find the defendant guilty of the lesser included offense of aggravated sexual assault of a child, and do not consider paragraphs 11 or 12. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, or if you are unable to agree, you will next consider whether the defendant is guilty of a different lesser included offense. 11, now, if you unanimously find from the evidence beyond a reasonable doubt that on or about September 15, 2011 in Bexar County, Texas, the defendant Mario Morales did intentionally or knowingly cause the male sexual organ of Mario Morales to contact the mouth of Sandy Sanchez, a child who was younger than 14 years, then you will find the defendant guilty of the lesser included offense of aggravated sexual assault, and do not consider paragraph 12. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, or if you are unable to agree, you will next consider whether the defendant is guilty of a different lesser included offense of indecency with a child. 12, now, if you find from the evidence beyond a reasonable doubt that on or about September 15, 2011 in Bexar County, Texas, the defendant Mario Morales did intentionally or knowingly engage in sexual contact with Sandy Sanchez, a female child younger than 14 years, by touching part of the genitals of Sandy Sanchez with the intent to arouse or gratify the sexual desire of any person, then you will find the defendant guilty of the lesser included offense of indecency with a child. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website to include, but not limited to, Facebook, MySpace, LinkedIn, YouTube, Instagram, Google, or Twitter to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers or tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any personal matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or prove any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 Judicial District Court, Bexar County, Texas, and suitable forms are attached. State, are you prepared to proceed with your closing?
Yes, Judge.
All right, you may begin.
All right. Good morning. I'm going to stand up here and talk to you a little bit about that jury charge. They're long and wordy, and so I'm going to take maybe 10 minutes to kind of break it down a little bit and talk about the elements of the actual offenses. So on the verdict form, the last page of that charge, you have different options, right? And 3 of those options are guilty of one of the 3 offenses that we've been talking about. The first one that you're going to consider is the continuous sexual abuse of a child. And these are kind of your check boxes, right? So the defendant, Mario Morales, 17 years or older, during a period of 30 days or more, did commit 2 or more acts of sexual abuse against Sandy, who was younger than 14 years old at the time, by intentionally and knowingly causing either the defendant's penis to contact Sandy's anus, the defendant's penis to contact Sandy's mouth, or the defendant touching Sandy's genitals. So when it comes to those details and those 3 acts, you don't have to agree. You don't all have to say which specific act it was. So you don't have to agree out of those 3 things. At the bottom, it could be any combination. And then you also don't have to agree on the exact date that it happened. You do have to agree that the acts occurred in that period of 30 days or more, just not the specific date. And then you do have to agree that the defendant committed 2 or more of those specific acts. Any combination of 2 or more in that 30 days or more. And if you check all those boxes and you all agree, that's a guilty for continuous sexual abuse of a child. If you don't, that's when you move on to the next possibility, which is the aggravated sexual assault of a child. So on this one, here are your check boxes, right? It's on or about September 15th, 2011. Mario Morales, 17 years or older, intentionally or knowingly caused his sexual organ to contact Sandy's anus. Aggravated sexual assault of a child, it can be either this last part that he contacted her anus or her mouth. So if you agree on either of those things and you check all of these boxes, that's a guilty for aggravated sexual assault of a child. At that point, if we said no to the continuous and we say no to the aggravated, then we move on to the indecency with a child by contact. And again, here's your new set of check boxes. So here you've got the same basic things, the on or about September 15th of 2011, the defendant, Mario Morales, intentionally or knowingly engaged in sexual contact with Sandy by touching part of Sandy's genitals with the intent to arouse or gratify the sexual desire of any person. And you have that little phrase in there, sexual contact. So just to clarify what that is, it's any touching by a person, including touching through clothing of the breast or any part of the genitals of a child, if committed with the intent to arouse or gratify the sexual desire of any person. So that's that last option. If you make it all the way down, then those are your new check boxes for the indecency of the child. And one last thing to clarify is statements made by counsel during the course of the entire trial, during the course of argument, if it's not supported by the evidence that you saw, or if it's about the law and that law is not matching up with what you see in that jury charge, it's to be completely disregarded. So if it doesn't match up with the evidence you saw or the law that's in the packet, it should not be considered. And that's all from me. The defense will get up and speak to you for a minute, and then you'll hear from Michael one last time.
Thank police support. Learned counsel, ladies and gentlemen, of the jury. I'm so glad Miss Collins called first. When I was a prosecutor, there not one talk first. She said, and everything she said, as far as I can tell, is absolutely truthful. The judge read to you a charge, which we call, and you're going to get to take that back with you, so you don't have to memorize it. You're also going to take anything introduced into evidence. I think a couple of reports and some photographs are introduced into evidence. It's this lady's job to make sure they're organized for you. Y'all can look at it all you want to. I want to thank you for listening. I noticed that Third County jurors are very good at listening. And I know you wanted this over with last Thursday. Many of sexual assault cases have their own complications. I try to bring that up in Bodar. Like when Ms. Pollard says, we don't have to prove which day it happened. Well, that's true. But it's really difficult for me to defend somebody. Say, well, I don't know which day it happened. It happened someday, maybe not. Because I'm looking for things like, were you unwrapping Christmas presents? Was school out? Was school in? Was it hot in the summer? Cold in the winter, like this morning? And there's testimony that goes to different people like uncles, aunts, and doctors. We agreed in Borgard that children can lie. I think we also agreed that they can be brainwashed by what I call the evil mother-in-law, the evil mother, for all sorts of different things. You really don't want to know that. We should be able to agree that a second grader doesn't have the mental capacity for fifth grade. I picked those dates because that covers when Sandy says these acts were done to her. And that's part of growing up. Like Sandy said, I understand now what was happening then. And I have no problem with that. We all grow up and learn things. I just was surprised when I asked 19-year-old Sandy to add 3 and 8. She couldn't do it on the stand. Might have been nervous, but I thought that was a really easy question. You got to realize that Sandy has told her story repeatedly to the mom, her aunt. I'm not going to include the uncle. Intake at the Center for Miracles. The doctor who looked at the Center for Miracles. Detectives and prosecutors, to the point that anything that may have been untrue, they feel true. In a sense, there's no evidence of sexual assault or abuse. And what I mean is, I'm a troglodyte. There's no redness any front or back. Well, heck no, not after 11 years. There's no tears, parts of her body or sexual organs or genitals. There's no semen to be found. There's no PTDs. There's just none of that extrinsic evidence that I'm always looking for to corroborate what happened. The timeline is something of a shambles. You guys figured out. I know that the state doesn't necessarily mean September 15th, but the state picks the date, they get to go on or about. I don't think it's appropriate if you have a young person, but in an era like it was summer would be a close enough date for us to figure it out. The only thing is if you think it really did never occur on any dates, you got to find my guy not guilty. Dr. Stewart, what a nice lady. And she was the same. I could never say same without asking an examiner, but same stands for sexual assault nurse examination. And she was talking about Sandy, how she believed Sandy particularly because Sandy gave sensory detail, saying that when my client's penis allegedly was in her mouth, it seemed like forever. And there was really no other sensory detail of the many incidents that my client may be charged with doing. And so it's good to say, I believe because, but one incident, is that truly enough to find my client guilty? We don't know how Mario took off his clothes at different times if he did. We don't know if she was on her back, on her front, on her side, on her knees. He doesn't talk about what color his penis is. Well, penises have color. I don't mean just black or white, I mean different shapes and stuff. She didn't say anything about his shape. Like it was the biggest thing she ever saw, or it had a little bend in it, or anything like that. So nothing empirical can not mean that sexual assault did not happen. So, anyhow, Uncle Brago says, I don't look to see if Sandy has breasts. I wouldn't do that. Well, unfortunately, this is a court of law. We try to figure out things according to what the law tells us. And unfortunately, you have to have breasts. And I can submit to an 8-year-old girl does not have breasts as it's defined in the law or Webster dictionary. Ruth, the mom, she was calm and serene. You know, that sort of like this plan is going on its way. It's doing what I wanted to do. I don't know if that's true or not. For a child who was sexually assaulted repeatedly, she saw nothing, she knew nothing. There was no sorrow she saw in Sandy's face, no extreme quietness, no avoidance of talking to her about things, no lowering grades. Came from a teacher about her having difficulty in school or being on the playground or something like that. She noticed nothing, no sorrow, no quietness, no avoidance, no Sandy not rubbing her body where the penis may have been rubbed too. And I would look for that, no finding a pubic on clothing or her body. Contrast that with Mario's mom. She gets a stand and she says, I know how serious this type of offense is. I love little Sandy and I still carry her photograph. I think we have a copy to take back. She's had that for 11 years. That was the time when Sandy was her granddaughter because of marriage of Mario and Rick. She wept. So I've already told you to take all the exhibits in your deliberations. You have on that back page, you might, first off, you get to go read the charge all over again. Secondly, I suggest you maybe look at that back page and say, okay, these are our choices. Sort of put them in your mind before you get there. There's not going to go into what the caller did. I only hope that you can choose a first version says not guilty. I like the Scott, sometimes it's not true. Remember what I said. It is just as bad as Sandy sexually assaulted as to convict somebody of something they didn't do and make them all convicted. That's all I have to say. Thank you all very much.
State.
Thank you, Your Honor. So I want to go over basically the state's evidence, or really all the evidence in this case that's been presented to you by both the state and the defense. So here's all the witnesses that the state presented to you. I'm going to go on kind of one by one what each one of these people proved to you to convict Mario Morales to be a child sex offender yet again. So Roxana Rosa, she's our fingerprint engineer, and we just a little bit of overkill, but what we did, she was able to do for you, she's going to compare the fingerprints that were on his judgment and what she took from him here in the courtroom. And she's actually the supervisor. She's done thousands of these. And what she did to you, she proved that the fact that Mr. Morales is a already convicted sex offender. So I already have that note going in. Our second witness for you is Sandy Sanchez, the victim. So what she was able to tell you is about these different incidents that has happened to her over a number of years. I'm going to go through each one of those individually. But what did we get from her? And what Dr. Spiller said that's really important about these things. There are a lot of details from her about these incidents. Details about lollipops, details about what it felt like, details about where it happened, what house it happened in. So she's able to provide those details for you, what Dr. Spiller called those idiosyncratic details. Her emotion on the stand. I don't know if you recall, it's been just last weekend. She cried through most of it. And there's even points where it looks like she's getting physically upset and talking about things like a lollipop. I mean, this is years later. She still can remember that. It still affects her to this day, understandably. And she's able to tell you that specifics and details on some cases, but also recall when we had her on redirect. She's able to tell you this happened just not more than these. It happened more than just these incidents. Right? These are the ones I give you really good details on, but it happened more than this. What's most important about Sandy Sanchez is that she has no motivation to fabricate or lie. The only thing that she got from this was to take the stand, tell 14 strangers, the judge, the prosecution, the defense attorney, and in front of her, the person who did this after her, the things that happened to her and her body when she was 8 to about 10 years old. What also did she have to do? She also had to go through that same exam. Right? Where intimate parts of her body at 15 years old were looked at. We're talking about her vagina, her anus. Why in the world would she undergo all of that to make up something against somebody she gets nothing from? It makes no sense for her to be lying. The defendant was out of her life for years at this point when she outcried. It's not a matter of this divorce or her, her mom. I think Mr. Hyatt referred to this like the evil stepmom. What does Brenda have to gain? Not Ruth, but Brenda, right? What does she have to gain from all of this to try to get her daughter to lie about these things and then to make her undergo all these things? What does she have to gain? Nothing. I think the first question I asked Sandy was, how do you feel about testifying today? I'd rather not be here if I don't have to. And that's understandable. Like, who wants to take the stand and talk about parts of their body and the things that somebody did to them when they were 8 years old? What's important, she didn't know at the time that the defendant was a convicted child molester. We know that she knows that now when she's older, and things might have been different, but that's what we have. So, talk about the 4 incidents, specific incidents that we proved to you. This is the one where she first, it started when the defendant was showing her pornography. Remember, she's like, I didn't know what it was. Makes sense for an 8-year-old not to know what that is. And then it led to him telling her to lay on the ground, to take off her pants, take off her underwear. And she had this grown man, when this child is 8 years old, touching her vagina. And she says, I was confused. I didn't know what was going on. Makes perfect sense for what an 8-year-old would be thinking if this was happening to her body from somebody who's supposed to be a father figure in her life, somebody who's supposed to be protective of her. So this first incident is the indecency with the child by contact, right? She says, it's touching my vagina, skin to skin. There's no penetration with the fingers, but it was touching. So that's the 4th predicate act that we talked about. Those Catherine talked about that checklist. This is number 4 on that one. So the second incident. This is the one where she went to go get the hairbrush in the room. That's where it started. And when she walks in, she sees the defendant standing there, naked, or I'm sorry, wrapped with a towel. He had just gotten out of bed. Closes the door, tells her to take off her bottoms, her shorts, and her underwear. Tells her to lay with her onto the bed. She lays on her back. She's very specific. Her bottom half's hanging off. She's 8 years old, so I imagine her feet can't even touch the ground. So I asked that question. Just dangling in the air. And what does he do? He grabs the lotion and then he starts to rub her vagina with the lotion. He rubs her anus with the lotion with his hand. And then he put his penis into her anus and had sexual intercourse with her. And then after he's finished, then he tells her to go to the bathroom and then clean herself up. So this is proving to you 2 of the predicate acts. The first one is the indecency, the touching of her vagina with the lotion. The second is the aggravated sexual assault of a child. That is contacting her anus. I'm sorry, yes, her anus with his penis. So that's predicate acts 1 and 4 that we've had. The third incident is the kissing on the couch. There was no actual offense that happened on there. Other than it helps show that his intent of what he's looking for, right? The kissing on the couch. Then we're going to go to the 4th incident. This is where they're in the living room with her brother, and the defendant tells Sandy to go to his bedroom. Once he's in there, he pulls out a lollipop. And these are the sensory details again. Remember, it was a grape lollipop. Remember him unwrapping it. Didn't do anything. Does it tell her to take off the clothes? She says, clothes. Tells her to go lay down onto the bed. And then he gets on top of her, puts his penis into her mouth, and tells her it's like a lollipop. don't bite. And he continues to thrust his penis in and out of this girl's mouth. And then remember that he's switching in between the lollipop and his penis. This is when she's describing, remember, the flavor of on, like she's physically getting sick. Those memories, I'm sure, having that grape lollipop, and probably can't even eat a grape lollipop or a lollipop to this day. Those are the sensory details that Dr. Stoller talks about, those idiosyncratic details that helps you know she's telling you the truth. And in this case, she stops because the brother starts calling out. And this is the first time he tells Sandy, don't tell anybody. So this is the aggravated sexual assault of the child, his penis contacting her mouth. And that is predicate action. So just through Sandy, the state has met its burden, but we brought you some other witnesses just to help give you some additional information. We have Brenda Mora, which is the victim's mother. What she's able to do is she kind of fills in the timeline of what houses they were when, because understandably, Sandy as an 8 to 10-year-old can't tell you exactly when these happened, but she's able to tell you what house they were living at, which correlates directly to his sex offender records, his registration, where he's been telling law enforcement he's been living the same house that he's residing at with his wife. All makes sense. That met in 2001, they're divorced in 2014. And again, she's able to tell you before she even looked at State's Exhibit number 3, these are the houses, and it matches generally around the timeline of when he's registering his. Something I thought was also important, I didn't even ask it, it was the defense attorney who asked it on cross-examination. Where'd you keep the hairbrushes? Kept them in the bedroom because I did the girl's hair at that time. That also, again, corroborates what Sandy's telling you. Then we have Kelvin Frago, the victim's uncle. So what we really bring him to do is to show that this is something that's spontaneous. This is not something that has been fabricated in a way. She's with somebody who I'm sure is like a father figure to her at this point. And what he's able to tell you is that Mario, again, has been no part of their life for years now. And this was an unprompted outcry, something that it's not like he drugged this out of her. This is something that she comes to him. He knows that she's upset. Or he knows that she's upset rather. And asks what's going on. And then she discloses he's been doing these things to me years after Mario's already been out of her life. Next we have for you is Dr. Stoller. She's our board certified child abuse pediatrician. She oversees the sexual assault nurse examiner program at the Children's Hospital San Antonio. She's an adjunct professor at the medical school. So she teaches to-be doctors and doctors this particular field of medicine. She talks about those idiosyncratic details and what those mean. This helps you know that Sandy is telling the truth because those are things that she experienced, right? That she's going through, that she remembers, that you had to have been there to remember. She's also talked about the normal examination. Normal is normal for these cases, right? I know the defense attorney wants to talk about, well, there's no tearing, there's no redness, no STDs. Well, I think it was like 95 or 98% of cases, that's where there's no sexual abuse, you don't have it, right? So that's normal in this case. That's consistent with Sandy's statements, what her truth, what the truth is. Something also in this case is that she diagnosed Sandy with PTSD, something that she doesn't normally do based on her reaction to telling what happened to her body when she was a child, right? This adds to Sandy's credibility. And then she also talked about what I call patterns of disclosure, or when children outcry. And that the fact is that this is normal for kids not to say immediately when something happens, right? They're in a situation where, in this case, Sandy didn't know necessarily what was happening to her was wrong. She also had somebody telling her not to tell her, somebody that was an authority figure in her life. So it makes sense that she didn't tell immediately when that's consistent. Then we finally had for you Dr. David Gearman, who had worked primarily on child cases, he worked on cases involving child abuse during his career, and especially at this time. Really what he used to do is tell you, basically the state, we've crossed all our T's, dotted all of our I's, that we've looked for the evidence in this case, all that can be found, and we presented it to you. Talked about the unusual way that he got this case, that Brenda had to called over to Child Safe and wanted to report it, and that he had initially assigned this case to himself. And then he talked about the course of his investigation, who he talked to, what evidence he gathered, and what he considered, and eventually what step he took. So the state has clearly proved to you beyond a reasonable doubt that he's guilty of continuous sexual abuse of a child. I want to talk about the defense witnesses just for a second. So the first we had was Michelle Morales, which was the defendant's sister. She is trying to claim now, years after the incident, that she has specific memories of just one particular months and days of when the defendant is living with her, despite it seems that she's surprised to find, oh, well, the state might actually have evidence that he's living somewhere because he's registering these places, and she can't reconcile the two. It's inconsistent with the defendant's sex offender registration records in this case, so it's not really a credible witness. Second, we have is Josefina Trevino, which is the defendant's mother. She tries to say initially, I think defense has argued that she's really close with Sandy. I don't know if you recall my first question with her. What's her date of birth? She knows all her other kids' grandbabies' dates of birth, but she can't tell you this one. Because now she's close with her when it matters, right? When she's here trying to defend her son. She also claims that the defendant lived with her during a period of time. And I think what's important for her is she got together with the sister to make the timeline, which the defendant just happened to have with him on the stand. Yeah, that's not colluding together to find a timeline that works with the evidence after you reviewed it. Okay. She can't remember other life events. Well, when did they get married? When were they together? Anything like that. She can't remember any of that. And when I kind of pressed her on those, what was her answer? Well, I don't have such a good memory. Okay. Thank you, I guess. I'm not sure if she doesn't have a good memory, but I can confidently say that she's most likely not telling you any of the truth, because she wants to lead off essentially with a lie that she's close with Sandy and she's kept this picture for 11 years. I don't know how to pronounce her last name. I don't remember on the direct. It's like, well, it's her middle name, Michaela. It's not her last name on there. And again, she's inconsistent with the defendant's registration records. She also wants to tell you, I can remember these months and days again that the defendant was apparently living with me or my daughter, but she can't tell you when they were married or any of these other things. Makes no sense. What I think is important about her testimony is she again substantiates that there is no reason that she can think of. She can't even make up a lie as to why Sandy would be lying about this, right? So again, Josefina is telling you there is no motivation to lie in this case. Finally, we have defendant Mario Morales. I want to start with, what do we know about Mario Morales? Well, first, he's a convicted child molester. It's a 12-year-old victim. The victim was, remember, his ex-wife's stepsister. And his story is that I was waking her up in the morning, right? And I accidentally touched her breast. Well, what's consistent with that case in this case? Number one, it's a girl, a young girl. Number two, it's somebody in the house, right? Based on his testimony. Somebody he has access to, somebody that's easy to perpetrate on. Remember these child breast questions. I don't want to keep asking about it. There's no allegations any indictment about this. But they keep asking people over and over again about child breast. Oh, I don't look at her that way. I don't look at her that way. Well, it's interesting because that's Helen Frago's answer to it, right? After he's heard that testimony, he's like, oh, that's a good answer. Might as well give that one too. Don't look at the victim that way. Well, I'm calling BS. All right. Clearly you did, because you are convicted and you went to prison for molesting a 12-year-old. We also know that he's also been to prison for violating a sex offender registration. So a 2-time over convicted felon. So what do we know about Mario? We have through State's Exhibit number 3, his child sex offender registration records. What do we know? He's lying to police, apparently based on his own testimony, because lying about his registration is a lot better than, or has less penalty been lying about, or telling the truth about rather, molesting Sandy for a period of time. His timeline, where he remembers these specific dates. He can't tell you what year he got married. He can't tell you when he got divorced. They want to argue, well, he wasn't part of the divorce. He can't remember that he signed a waiver for his divorce in 2013, okay? He's trying to say that he got divorced in 2011. No, clearly it was 2013. Again, wants to tell you he can't remember months. He moved in and out with mom, sister, and Brenda 10 years ago. But he wants to say he remembers that, but he can't remember these important life events. Again, he tells you that Sandy has no motivation to lie. I went through this with like some of my last questions with him. What does she have to gain from this? Nothing. Remember the other question I asked him? What do you have to lose? Everything. Right? Of course, he's not going to take the stand and tell you he did it, right? He pled not guilty. I'm not shocked to him to say, oh, no, I didn't do this. Of course, he's going to do that. Because he has everything to lose by being convicted in this case. The state has clearly met its burden in this case, that the defendant is guilty yet again of taking the innocence of young children within our state. I'm asking that you go back and that you return a verdict of guilty. I believe that it should be proved to you beyond a reasonable doubt the continuous, but if for some reason you're unable to be unanimous on that offense, you clearly have two other things that he is absolutely, and that's the aggravated sexual assault of the child and the indecency with the child. So that asks you go back, you select your presiding juror, and that you find this defendant guilty, and then we can move on to punishment about when we're going to let this person out in our community. Thank you.
All right, ladies and gentlemen, I'm going to give you permission now to begin your deliberations. I know each time I told you not to do any investigation, so now is your time to deliberate. I'm going to ask Russell and Daniel to remain behind, and the deputy will take you back to the room for deliberations.
Hey, what happens in Vegas?
Hello, hi. Oh, thank you so much. I'm sorry, what? Oh, yeah, I mean, that's complete up to you. All right, thank you.
So I know. I think I was looking at it and it was working on mine, so I don't know if it's your. Were you looking at that one? Just yesterday.
Ms. Abrams,
I think it might have been one.
Bashan, who are the persons we're waiting for?
But.
I'll let her know now.
All right, thank you.
What?
Correct.
What?
Yeah, sorry.
I mean, yeah, we just. What?
All right, and this is done.
I don't know about it.
Yeah.
For the thing you didn't watch.
Who's here on Jessica Medina? Jessica Medina.
Present, Your Honor, coming up, coming up. Your Honor, prosecutions.
Okay. All right, Ms. Ferguson, Jessica Medina, where are you?
She announced, stop the call earlier.
No, where is she?
She's out of the courtroom right now.
Yes.
She didn't announce that she's been here too.
Okay, so she'll need to come back in and we'll give you a reset date. But she needs to come back in.
Yes, if I may say the following. I think I might have thought that I was gonna take a jury trial, this wasn't gonna happen, but I think it's something. You want me to have her come back in and
Yes.
sign it?
Yes,
Sorry about that.
no problem. All right, thank you.
Thank you.
Running in or walking into the door.
Can you stop the video for a moment?
I can figure it out.
Yeah. Yeah, I was thinking that, you know. This is.
Yeah, I know. A lot of, so I need to try to.
All right, you can start with you.
So.
Person on the back row, you need to pull off that hat. Hi, Bo, how's it going?
I'm real good, Judge. How are
Top
you?
of the morning.
Top of the morning.
Yeah,
Right, I know that it's week behind you.
yeah.
And the next select we can stay on the sidelines. So good for you. Oh, good.
For you, yeah, I will do that. Yeah, it's been a long,
Oh, yeah.
it seems like 3 years.
So you're thinking, what was 8 hours? Sleep? You need to.
Who needs 8 hours? Yeah.
So when you're in bed, your foot's going.
Yeah,
Oh, I'm glad.
well, it's good seeing you.
I was telling Michael's gotten real polished. That was a real professional closing of his.
Yes.
Wow.
No, that's. I don't know what it is.
Yes. What is her name? Chiso? Yes.
Thank you.
Okay. And who's the defense attorney?
Yeah.
Yes. Oh, that's fine.
Yeah.
All right. Can I see the file on Kayla Connor? All right. Could I see Kayla Connor, please? All right, everyone, you need to whisper. All right, so Ms. Connor, do you know why you're here? Yes, so what are you not doing that you're supposed to do? I'm sorry, you need to speak up. No, let me just tell you the report I've received. One, there's an issue with your testing positive for marijuana. You can unfurl your arm. So why are you testing positive for marijuana? No, I mean, you are, it's not a matter of you shouldn't be, you are testing positive for marijuana. So I'm trying to figure out why you're testing positive for marijuana. Are you pregnant? All right, so obviously you keep rubbing your stomach. You want me to know you're pregnant. So I've taken note of the fact that you're pregnant. So my question is, why are you using marijuana when you're pregnant? No, you're still doing things. I mean, this is what ends up happening in court all the time. People want sympathy from me and mercy from me because they want to come in and let me know they're pregnant by rubbing on their stomachs and all of this. And then they're not doing things to protect their child by using marijuana and by not taking a UA when the court tells you to take a UA. So those are issues. Now, when you do a UA today, because you are doing one, everyone needs to lower your voice. When you do a UA today, because you are going to do one, what are the results going to be? All right, you're going to do a UA today. And the other issue I have, which I don't understand, the field team visited your home or where you were living. There were 3 small children in the home, ages 3, 2, and boyfriend's older child from previous relationship was in the home at the time. So why are there so many children in this home?
Son was visiting and the 3 toddlers at home.
So you have 3 toddlers. How long have you known this boyfriend? Okay. And how is your Child Protective Services case going? Have you been in contact with your worker? Where are you currently living? No, that's not my question. My question is, where are you currently living? So you're not in, are you in Bear County? Did I give you permission to leave Bear County? No, my question is, did the court give you permission to leave Bear County? That's either yes or no. Your contract is not with probation. Your contract is with the court. So I didn't give you permission to leave Bear County. And the fact that you have so many children living in your house, obviously someone has to do something to protect the children who are living in your house. And the way that is accomplished is by me requiring probation to do field visits. and you are actually on probation for injury to a child by omission. And the facts of that case are the same thing that's happening in this household right now. You got children who are living there, parents who are using marijuana, whether they think it's legal or not, and constantly bringing more children into a situation when you don't have stable housing. I don't understand why people do that. You know, you don't have stable housing. You have 3-year-old, 2-year-old pregnant, and then your boyfriend has another child who's coming to visit. People keep having children and bringing them into unstable situations. It amazes me that somebody would make the conscious decision to have a child, and now you're living in an Airbnb, don't have a place to stay, you're on deferred adjudication, using marijuana, moving to locations without getting the court's permission. Did you give your CPS work? Did you tell your CPS worker you're going to be moving? All right, Ms. Loper, are you the CPS worker in this case? You're muted.
Yes, I
Yes.
am.
Are you the CPS worker in this case?
Yes, I am.
Your volume's not on.
Okay, yes, I am.
All right. Are you aware of Miss Connor moving to another location, not in Bear County?
I knew that her boyfriend got a job in Austin, but they were supposed to let me know so that I could transfer the case to a worker in Austin.
So that's either, did you know she had left or did you not know?
I did not know.
Mhm. All right. And then let me just tell you the report I got from October 5th, what you're bringing your children to. Field team made contact with the defendant, and the following information was noted. Upon entry, the sofa was blocking the front door to prevent the children from walking out, which means that children are not being supervised if you have to put a sofa to block the front door. In the living room, there was a mattress and scattered mess all over. Her daughter was watching TV in the living room. In the front room were her 2 boys behind a closed door playing on a foam mattress. There was no furniture and the room was a mess. The boys walked out once the door was open. In the back room, there was furniture and personal belongings scattered around the room. In the guest restroom, there was also a scattered mess all over. Defendant was advised CSO would be visiting frequently as ordered by the court. Defendant is aware her residence needs to be organized and clean. Defendant stated she is aware the residence is a mess and has not had time to clean, but will. Defendant stated she is not employed at the moment and currently pregnant. So why do you have your children living in a unclean home?
I had told them. The one who couldn't from her dad, so things were a little messy on top of his son coming over and visiting and stuff. And when they came the next time, everything was clean. They even said something about how they had seen an improvement on the mess. So.
All right, I want a UA today. Do you need any water? That's either, if you need some water, we'll make sure you have water. Do you need any water? All right, so I'm going to want a UA today, and we're going to do it in court today. And then we're going to come back after I get my result. All right, Ms. Loper, if you want to, we're going to see what the result on this UA is, and then we'll go from there.
Okay,
Thank you.
thank
I'm
you.
going to put you in the rating room.
Okay.
Joshua Carroll. Mark Ivy. Julius Clayton. Where are you? You need to get on the front row. Amber Grant. Thank you. Pedro Rodriguez. All right, you need to be on the front row. Robert Carter. All right. Mariah Rodriguez. And Mr. Caleb Coleman is by Zoom.
Yes, ma'am.
All right, thank you. Your attorney is in the courtroom. As soon as everyone's ready to proceed, we'll take up your matter. All right, who's here on Julius Clayton?
I am.
Yes. Why are you late? All right, and my understanding that you're still requesting a jury trial because I see where your plea deadline date has expired. Is that correct? All right, Ms. Ferguson, I need a jury trial date for Mr. Clayton. All right, January 10th is going to be your jury trial date. You need to make sure you're dressed for trial. It'll be at 9 a.m. All right, Ms. Ferguson will give you a reset form. Who's here on Charles Garley?
It's me as well, Your Honor.
Good morning. And are you the attorney on
Also
this?
subbing in for Mr. Navy. He should be here shortly, Judge, because he has a few other matters to attend to. He was in Comal County, but I'm prepared to talk on Mr. Garley's case. So Mr. Navy has let me know that there was an internal affairs investigation arising out of this case.
Mhm.
So he's in the process of subpoenaing SAPD.
All right, State, do you have those documents or no? All right, we're going to recall this in 2 weeks. And we'll see if the state has those documents.
Thank you so much, Your Honor.
All right, Ms. Ferguson, I need to recall this in 2 weeks for discovery.
I can do December 1st.
All right, we're going to come back on December 1st for discovery. And if you can let the state know specifically what you need or what you don't have, and we'll see if we can have you obtain that sooner rather than later.
Absolutely, Your Honor.
And Ms. Ferguson will give you the reset form. Megan Tierney.
Morning, Your Honor.
Good morning. And where's she?
It's not separate.
Ah.
The docket.
Yes.
It's separate, but it's 17th.
Mhm.
Jury trial, she's currently up. Then staffing the program.
Mhm.
We did that last week. Sally on the was not present. So they're asking for another at least 2 weeks. If we can get something in the next couple days, get her in. But if not, they don't have another. So, and are able to. 2 weeks instead of.
All right, Norma, on Tierney. Can you put this on December 1st?
Do you have the case number?
Yes, it's 2022 CR 5343. All right,
Thank you.
you're welcome.
Appreciate it. Nice to see you.
You too. Nicholas Moran. Good morning. Where's your client? Oh, come forward. So where are we? All right, Ms. Ferguson, what date to call this back for PTD? All right, we'll be back on December 16th. Get a reset form from Ms. Ferguson.
Thank you.
You're welcome. Christopher Rodriguez. This is a motion, correct?
They aren't ready.
I'm sorry.
They aren't ready.
All right. So state,
Yes, sir.
is there a reason the state's not ready on Christopher Rodriguez on the defendant's motion to disclose informant?
Yes, I did. I've been handling it and I guess something came up.
Okay. All right, when can you come back? When will you all have this ready, state?
I will check, I believe he'll be here tomorrow, but if I can just let him in, just confirm that he will be in.
Okay, just give me a moment. And if you all can confer on a date.
Okay.
If that doesn't work for you, defense.
Okay. Should I have my seconds?
All right, Jessica Medina,
I have her back. That's
come
right.
forward. Come forward. Have you had all the discovery in this case, counsel?
No, it hasn't been ready yet.
Okay.
It's a brand new case. We just requested it. I'm trying to get ahead of myself and I moved to have this setting.
Okay. All right, Ms. Ferguson on Medina, can I have a 30-day reset for discovery? State, will that give you time to be prepared to make an offer at the next setting?
How much time did you give us, Judge?
It's going to be 30 days.
Yes, Judge.
All right. What date, Ms. Ferguson? All right, we'll be back on December 16th. Ms. Ferguson will give you the reset form.
Thank you.
You're welcome.
Don't leave again.
Thank you.
My bad. My bad.
Today. Good, how you doing?
Hello. Hi. Thank you. Oh, thank you. Happy Monday, right? And you dated everything. And you're wearing a tiger on your shirt. Yes. Yeah, I'm like, yay.
Well, thanks, guys.
It is.
Hello, morning.
Congrats on the win,
Oh, thank you so much. I appreciate that.
which I was gonna be part of this way.
Oh, yeah.
Well, if he does want to do it.
Yeah. Yeah. Here we go. Yeah.
Yes.
All right, Anthony Villarreal.
This will be real.
All right, we're here. Oh, and you're on that side. So where are we on discovery?
We have discovery. I'm in the process of reviewing it. It's about 360 gigabytes. But we have everything, state looked into it all. And they're previously investigator. They got me all his files. Right now, it's a matter
Oh,
of
okay.
going through it all. We have not
Nicholas
taken offer
Crandall.
from the state. I think they're still going through stuff on their end as well. But I anticipate we'll have an offer relatively soon, and we'll have a quick decision on whether it's going to be a plea trial or what have you.
All right, Ms. Ferguson, can I have a 30-day reset on Anthony Villarreal, please?
December, so I said it here. 16, perfect. We had a motion to relax or modify conditions of bond to allow for work. I don't know if it's just stayed here or got sent to Mackville.
Have you conferred with the state?
I will talk to them again. I know we talked briefly last time.
All right, well, talk with them and then I will hear it.
Excellent. Thank you, Judge.
You're welcome.
And that was the 16th, right?
Yes.
Thank you. I'm not see what I forgot for this morning. Thank you, Your Honor.
You're welcome.
Sign something. I don't know, it's still.
Sorry, bud.
No, it won't.
How about letting you go? So the holidays that,
When they come back on a motion on that. Caleb Coleman.
Yes, ma'am.
All right, you need to show your video, Mr. Coleman. All right, on this case, I believe there's a discovery as it relates to medical. Is that correct? All right, everyone, please whisper. All right, where are we on that?
Judge, I guess this is my first time jumping on the stage. We don't have medical records. My understanding that case never been in our possession. We were trying to get them from the complainant, but she is not. He hasn't been responding from it. I read, there's something though that we will try to get them ourselves through the hospital. But I guess technically, like, we've complied with all discovery, submitted everything that's in our possession.
So what are these medical records related to as it relates to this case?
And she was one of the studio, and we've been asking for it since June.
All right, Ms. Ferguson, I want this set for 30 days. There will be a hearing. Everybody, if you want to subpoena the complainant, people can subpoena the complainant and have the complainant bring their medical records. We'll do that way. If you don't receive them or if the state doesn't see them, what date? All right, December 16th. So everyone subpoena whomever you need to subpoena. Is there any objection to Mr. Coleman appearing by video? Okay. All right, so the defendant can appear by Zoom and we'll come back on December 16th. Everybody subpoena whomever you need to subpoena. You're welcome. Mr. Coleman, you're excused.
Thank you, Your Honor.
You're welcome. What is that? No. Okay, well, I knew this. Okay. Thank you. All right, Ms. Connor. All right, according to probation, you're positive for marijuana. I'm not allowing you to transfer to Austin. So whatever job your husband has, you need to be here in Bear County. And probation, I want those field visits done 3 times per month randomly until further notice, so we can make sure that the children are okay. So I don't know what's happening in your CPS case. I deal with the criminal side, not the civil side. They're allowing you to go to Austin. I guess that's what they're allowing. I'm not allowing it. If you want to be allowed to live in Austin, then you need to do better on your probation. And better on your probation is not having a house that, from the reports I'm getting, is messy with couches blocking doors and you testing positive for marijuana and being pregnant. And so that means that either you are using marijuana outside your house, in which case the children are being unsupervised, and that would explain the couch blocking the front door, which is a fire hazard. If there's a fire in the house, how do you expect firemen to get in the house when you're blocking it with couches? And if your husband or boyfriend or the father of your children doesn't want to step up and help you if you have medical issues, then maybe you shouldn't be in a relationship with him. But you are setting a horrible example for your child. And I don't know about this other mother who lives, who knows where, allowing her 9-year-old to come and stay with you, who is on probation for injury to a child by omission. People need to stop letting their children just stay with random people that they don't know and they don't know how they're living. So CBS can do whatever they wish, but I'm telling you right now, your probation is not getting transferred to Austin. You're not allowed to live in Austin. You're going to be living in Bexar County, and this court is going to have to keep an eye on all of these children who are under the age of 3 and the 9-year-old that some parent somewhere seems okay with allowing you to supervise. So probation, she's not to be in Bexar County.
Yeah, yes, Your Honor.
And if you live in Bexar County and you leave this county to go when I didn't give you permission to, a motion to revoke is going to be filed. Is there anything else?
Your Honor, a TAP evaluation was revised to, for a recommendation of safe P. I don't show that on here that she has a condition for any type of outpatient treatment at this point. If you're not going to do a residential mandate, can we ask for intensive outpatient
Yes,
treatment?
intensive outpatient treatment. And I'm going to want her tested for levels.
In addition, can we set a maybe a clean date or?
Well, if her levels are increasing, file a motion to revoke. So if your levels increase, a motion to revoke is going to be filed. And let me just tell you something. People think marijuana is okay, but let me ask you this. Is it okay for your 3-year-old to smoke marijuana? Do you have any problem with that?
Of course.
All right. So the child that you are carrying, that you keep rubbing your stomach and you want me to know you're pregnant, guess what? When you're smoking marijuana, you're letting an unborn child smoke marijuana. Just imagine that child in your stomach, kicked back on a couch, smoking marijuana, because that's what you're doing. Do you understand? I'm not going to tolerate that, because use of marijuana is not allowed on probation out of this court. And if your levels rise, we're not going to have a compliance hearing. We're not going to have a conversation. I'm going to get notice that your levels have gone up and a motion to revoke is going to be filed. And wherever you may be, at your home or in the grocery store at HEB or wherever it is, a warrant's going to be issued. And if police see you there, they're going to arrest you because you're pregnant. They will handcuff you in the front, which they're supposed to do. And you will be taken to the Bexar County Jail. And while you're at the Bexar County Jail, you will either make bond or you will not make bond. If you don't make bond, you will be brought over to sit in the box as you see other people, and we will have a hearing on what to do. And what to do may end up you going to prison for up to 10 years. Do you understand?
How often would you like the UAs?
I want it at least once a week, randomly each week. And so do you still want to pretend to me like you have not been smoking marijuana?
Your Honor.
Okay, she's still pretending. So I want UA randomly once a week throughout the week.
Okay.
All right, thank you.
Thank you, Your Honor.
CPS, is there anything else you need?
No, there's not.
All right, thank you.
Thank you.
Oh, I'm sorry. Could I have the file on? I need to write something in that file on Connor. Sorry about that. Thank you. Who's here on Jose Lozano?
I am, Your Honor.
Yes.
Morning, Judge.
Good morning. And where is Lozano?
Please.
All right, come forward.
He was there, Judge. I don't know where he went.
All right.
He was there, Your Honor.
All right, well, have him.
By the way, congratulations.
Oh, thank you so much. I appreciate that. Have him come in and
Yes,
then
Your Honor.
we'll take this up. Who's here on Pedro Rodriguez?
Your Honor, he's present.
All right, Mr. Rodriguez, come up.
Top of the morning here, Judge.
Top of the morning. Hey, are you enjoying the cool weather we're having?
Sure am. Sure.
Yes.
I don't want 6 months of it, but this is nice right now.
It is. All right, so Mr. Rodriguez, why were you late today?
The rain. I work on 614 in Tranquil Theater.
All right, so Brenna, I give people a little leeway for the rain, but I arrived early. I was in the rain and I got stopped by a train, and it was the slowest train. I won't say the slowest train that you can imagine, but it was a slow train. It wasn't like Thomas the Tank Engine or whatever Thomas the Tank is. Train. Thomas the Train. It wasn't Thomas the Train. It was like slow moving. Here's
I came directly from work.
all right, so you got to make sure you're on time. You understand? All right, so what are we doing with Mr. Rodriguez today?
We received a second plea offer today, and we've discussed it and going to reject that. Send us for trial.
All right. So Ms. Ferguson, what we're going to do is we're going to call this. Can I have a December date? Since the offer was made today, I'm going to give you a plea deadline date.
All right.
Okay. And then the court will not extend any more plea deadline dates. All right, so we're going to come back on December 16th. If you decide not to accept the offer, then I will give you your jury trial date. Thank you. You're welcome. Chadwick Walker.
Morning, everyone.
Good morning. All right, court is calling 2022 CR 6939, State of Texas versus Chadwick Walker. Can I have parties announced for the record for the state,
Brian Grimmer.
for the defense?
Di pa kayo, Courtroom.
All right, and are you Mr. Chadwick Walker?
Yes, ma'am.
All right, we're here for a sentencing. You entered a plea to paragraph A. Punishment is to be assessed at 4 years in the prison. The state is opposing your application. And there's to be no contact with the law offices of Henry Gonzalez or 205 North Presser Street. Have both parties received the PSI report, state?
Judge, I didn't know this one was coming up here. I've not looked at the PSI yet. Sorry.
All right, well, I'll give you time to step back to look at that.
Thank you.
You're welcome.
Your Honor, my approach.
Yes,
Mr. Lozano's back in, Your Honor. He had gone to the restroom.
Jose Lozano.
Yes, Your Honor.
Jose Lozano. All right, what is happening with this case? It shows that, oh, there's a Joe Lozano and we're looking for Jose. Brendan, do you see what? Page 8. All right, thanks for addressing appropriately for court. So what are we doing with this case?
This is going to be the need of a jury trial, Your Honor.
All right, Ms. Ferguson, can I have a jury trial date, please? All right, you'll be back on January 9th for a jury trial date. And I'm going to need an acknowledgement of discovery before anyone leaves today.
Yes, Your Honor.
Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Do you understand? Otherwise, you have to plea open to the court. All right, Ms. Ferguson will give you your reset form.
Yes, Your Honor. The discovery, Your Honor. Okay.
Yes, thank you. Who's here? Nicholas Condiff? All right, what is happening with this case?
We rejected the offer, Your Honor. We need a trial date. I don't think that's something.
All right, Ms. Ferguson, I need a plea deadline, I'm sorry, a jury trial date on Nicholas Condiff and state. I need an acknowledgement of discovery in each one of these cause numbers. All right. Your jury trial date is going to be January 9th. You'll be brought over dressed for trial. You'll be brought over dressed for trial in whatever civilian clothes you have at the jail. If you wish to be attired in something differently, you'll need to sign a release for your attorney. Counsel, if for any reason there's an issue with the clothing exchange, just let the court know and we'll see what we can do to expedite that.
No, it's just something new that I need to release, because I've been doing it without the release
No, but you know, sometimes things change. All right.
all the time.
Yes.
Congratulations.
Oh, thank you so much. Yes, sir. Your client has a question.
I know you're not supposed to be in here in shorts and the clothes over there are there.
Okay, don't worry about it. Okay.
Oh, okay. My bad.
All right.
No, we will. I'll just, yeah. This way, your parents.
All right. Thank you.
Thank you, Karen. Excuse me.
Yes.
Thank you.
Oh, Ms. Conley, before you leave, though, the state is going to give you an acknowledgement of discovery.
Yes.
Thank you. Who's here on Christopher Rodriguez? Second, please. But the first, but if you've already said something, okay, thank you.
We got a new date for the motion to disclose the CI for next Monday, the 21st. If that's okay. Before.
No, December 21st now. I'm sorry, November 21st now.
Oh, okay.
Yes,
We
No.
do the 22nd.
no.
Oh, okay. Sure. Sure.
All right,
Monday, the 28th.
yes. Okay, we will see you then.
Wonderful. Thank you. You make a notation that they weren't ready today, Judge. It's not ready again.
Yes, I will put that in there. And is your client on bond?
Sorry?
Is your client on bond?
Yes.
All right, Ms. Ferguson will give you a reset date.
Thank
Okay. All right, could I have someone contact the state on this jury trial and also have Mr. Oh, there you are, and have Mr. Hayek here, please? All right, Ms. Ferguson, if you can call Anton Hike, please.
Thank you.
Okay, I appreciate it. Thank you.
It's a question. Can you mute us? All right. The court is going on the record in 2019 CR 9698, State of Texas versus Mario Morales. This is outside the presence of the jury. The jury has presented the following two questions. First question, is this print and sign or just signature required? The court proposes, after conference with the state and the defense, the court proposes, with reference to your first question, the presiding juror must print or sign their name on the verdict form. Any objections to that answer?
No objections by the defense.
No objection to the same.
The next question is, are we going to do sentence? After conferring with both parties, the court proposes the following answer. Regarding your second question, if the defendant is found guilty, he has elected to have the jury decide his punishment. Any objections from the defense?
I kind of would like to see the word sentencing since they said that as opposed to punishment, but really it's not objectionable, Your Honor.
All right, so any objection to that being the answer? State?
No objection to the state.
All right, is there a request for the jury be brought out and read the instructions? Or would both parties have no objection to the answer being sent back to the jurors?
No objections to the answer being sent back to the jury from the defense.
We have no objection to being sent back.
All right, thank you. All right, thank you. All right, are the parties ready on Chadwick Walker? Court is calling 2022 CR 6939, State of Texas versus Chadwick Bain Walker. Could I have parties announced for the record for the state,
Ryan Grimmer for the state.
for the defense?
Carrillo for defense.
And are you Mr. Walker? All right, Mr. Walker, I'm going to need you to speak up so the court reporter can hear, and most importantly, well, not most importantly, but so that I can hear as well. All right, according to the plea bargaining agreement, the defendant entered a plea to paragraph A of no contest. Punishment was to be assessed at 4 years in the prison. The state is opposing your application. There's to be no contact with the law offices of Henry Gonzalez or 205 North Crescent Street. Did both parties have a chance to review the PSI report, state?
Yes, Judge.
Defense?
Yes, Your Honor.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
None from the state.
All right. All right, well, I will tell you, the court has read the PSI report, and I always read the PSI report. And according to the PSI report, your client is saying he didn't understand the plea bargain agreement.
I read that also, and I brought it up with him. I said that he didn't understand it. He said I didn't agree with it, but he knows that's what he did it because of the 4 years of going to prison. But as far as anything else, he understands that he voluntarily made his plea and decision to go ahead.
All right, Mr. Walker, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record, please.
Chadwick Bain Walker.
All right, Mr. Walker, do you wish to continue with this sentencing and your plea as is?
Yes.
I'm sorry?
Yes.
All right. All right, state, you're opposed. Do you have any witnesses?
We don't have any witnesses, Judge.
Defense, any witnesses?
No, Your Honor.
All right, then the court will hear argument. State?
Yes, Judge. I believe, I know you've read through the PSI. The things that we believe that are most pertinent to the court's decision are, first of all, that Mr. Walker has never been successful on probation. He's attempted to do that even as recently as 2016, when he was put on probation for an evading second. Roughly 7 months into that, he was revoked because he had picked up new cases. Since the time he was put on probation in that case, he's been arrested 8 times for a variety of offenses, including the one that's before us today, Judge. He's had issues with the same type of behavior that we have here in front of the court today. He's been arrested for criminal trespass multiple times, and now he has a burglary of habitation. In addition, Judge, we believe he isn't taking any responsibility, yet he's coming to the court and asking for probation. The first step of any probation program is going to be to admit that you did something wrong that you need to rehabilitate yourself from. And I believe in this case, he doesn't have any remorse or regret for what happened. For those reasons, Judge, we are asking that you place him on, I'm sorry, that we ask that you send him to prison.
And Your Honor, just the simple fact of him agreeing to the 4 years and knowing that he could be going to prison and that probation would still be up to this court, he is accepting responsibility for his actions. He knows he was in a bad place and a bad time, and he's accepting this. Now, there's nothing in his history that I've seen that he's had any type of treatment before. And the probation and all the evaluations that have been done on him, they have recommended all this probation in-house structured probation. So treatment actually. So I asked the court I've talked it over with my client, and he said he will do whatever it needs to do that Your Honor believes he needs to have in order to be successful in his probation, and he will comply.
All right, anything you wish to say, Mr. Walker?
Yes, I'll take responsibility.
All right, so here's my problem. And your attorney will tell you, I always read the PSI report. My problem is you break into a home, and it doesn't matter to me if here's the thing. It doesn't matter to me if it's an attorney's place or not. It could have been the president of the United States. It could have been anyone. So I don't give any more weight to the fact of who the complainant is, in the sense that, oh my gosh, this is an attorney. I was a defense attorney. That plays no role whatsoever in how I consider a case. But my issue with you is that the complainant says that you broke into their offices, and their offices, from my reading of everything, there's offices at the front and home at the top of the stairs. And they asked you to leave and you did not. And they kept shouting for you to leave and you did not. And then they had to punch you, then you finally left. So those are my issues, because people can say they have mental health issues, they can say they have drug problems, they can have a host of problems, but that doesn't excuse committing an offense. And that's my concern in this case.
And Your Honor, if I may, and I believe that's where all this treatment that's been recommended, my system and changing his way of thinking and any substance abuse problem that he may have. And it's going to take a long time because he gets to that program that they're recommending. And I think and during that time, he'll have time to evaluate where the position he put himself into.
All right, okay. Just give me a moment on this. Deputy Mejia, if you could take everybody back, since we have a verdict, and we're going to come back on this
Yes,
matter.
sir. I'll take you back.
Yeah.
No, we still need the defendant.
Yeah.
Oh, okay, thanks.
Maybe it's a false security.
Really get to hear about that.
Yeah, that's interesting.
Have to read the words stand a little bit quick. If we can have jury call. Instead of asking one of them, that's their burden.
Do y'all have any witnesses? Okay.
If you want the jury asked.
Mr. Hayek, if it were to be a guilty verdict, do you have witnesses?
No, we don't, Your Honor.
Okay. All right, so then if it is a guilty verdict, we'll go straight into punishment. My understanding is that the state may have one witness, then we'll take a break so that we can work on the jury charge.
Whatever you say, Your Honor.
All right, thank you. Yes. We're ready.
All right, for a jury.
All right, everyone, please be seated. Ladies and gentlemen, it's the court's understanding that you've reached a verdict. Is that correct? And is it unanimous?
Yes, Your Honor.
All right, if you will hand the form to the deputy, please. All right, if the defendant could please rise. The verdict form reads, we, the jury, find the defendant Mario Morales guilty of the offense of continuous sexual abuse of a young child as charged in the indictment. You may be seated. Would you like for the jury to be polled?
Your Honor, the defense does not need the jury to be polled.
All right, you may be seated. All right. State, are you ready to proceed with punishment?
Yes, we are.
All right, do you have any opening statements?
Say have that opening statement.
Defense, any opening statement?
Defense, no opening statement, Your Honor.
All right, state, call your witness.
We call Davey Sanchez.
All right, you're still under oath. If you'll state your name for the record,
My name is Sandy Sanchez.
state.
Good morning, Sandy.
Good morning.
So now that Mario's been convicted, let's talk a little bit about how all of this has affected you, okay? So let's first talk about, has this or has this not affected your mental health?
It most definitely has.
How so?
I had to go through therapy for a minute.
And what was the therapy?
The therapy was to get me through my trauma.
Are you still in therapy?
No, not currently.
Is there a reason?
Because I felt like I wanted to do it on my own.
Has this affected your relationship with people?
I would say it has.
And how so?
In a sense that I'm not comfortable with being with an elder man in the room by myself.
Has this affected, like, I know you're 19 now, right? Has this affected a dating relationship, your romantic relationship?
I would say so.
And how so?
I have trouble trusting them.
Has this affected your relationship with any of your family?
No, I wouldn't say so.
Is there anything else that the jury should know about how Mario and what he did to you as a child has affected you?
Not much really, just that it's really hard. To this day, it'll still come up in my mind, and there are times where I just want my mind to shut off because it'll pop up. Or I'll simply just be waiting in line and a man behind me will just walk up behind me and I get stiff. And it's not like he's there to do something to me. It's just my subconscious.
I'll ask the question.
Defense.
No question from the defense, Your Honor.
All right, you may step down. Could I have parties approach, please?
Yes, Your Honor.
And judge, at this time, the state would just formally reoffer all of the state evidence from the guilt portion of this trial and the stand rest.
At this time, the defense rests, Your Honor.
All right.
And closed, I guess.
All right, so ladies and gentlemen, I'm going to give you a brief recess. We're going to be back at 12:30. And at that time, I'll read to you the charge as it relates to punishment. All right, does everyone understand? And again, there's to be no research, no deliberating on punishment. I will let you know when it's time to deliberate to the second phase of this trial. Does everyone understand? And do not discuss it amongst yourself. Do not discuss it with anyone else, and make sure your badges are displayed. So if everyone could please rise for the jurors. All right, everyone, please be seated. Okay, so, and I just need the punishment charge for that. All right, all right, thank you. Bye-bye.
And Judge, if we could just for purposes of the record, I would like to ask the court, I know he's in custody, but that he be reminded what his punishment takes today to finish.
All right. Mr. Morales, you're going to be remanded without bond. And we will continue with the trial and we'll see where we are at that point, okay? All right, thank you. All right, thanks. And how much time are you asking for closing?
No more than 15 minutes.
When do people say no more than 15 minutes? Okay,
I gave you time back.
so no more than 10 minutes, is that what you're asking for? Okay, thank you.
I gave you time back, that's all right.
We're- So it should be, they're telling me that the punishment charge should be here very quickly. Now, we're gonna finish with yours today. But I said, we're gonna finish with yours today, but I want to finish with
Yes, sir.
this charge.
Yes, sir.
People are not recognizing you.
All right, thank you.
Good job.
No, not right now, because I want to finish with this. Yes, two.
All right, ready to go. Rearrange the punishment 25 a lot. They didn't follow those. Yeah, she says, I have post traumatic stress time. I'm gonna. I like the city. That's really valuable. What do you want me to say? I had a good day. Kind of a guilt innocence argument, but it's. You know, a lot of people need to take easy. Yeah, I have problems. Oh, Judge, thanks. Can you do it at 10:30? Sure. Yeah, I can't handle days like this. I was apparently 6 or 7 cases, but with this one down south. And I did. I think I'm supposed to do 176 right now. Maybe I did. Because I don't have a good copy. You need some? That, this stuff is so
So then are there, where messages on it, I guess, that your people have that shouldn't be. Makes sense. It's kind of online, I think that's online, it's kind of an application or something. Because they say it was all done online.
Well. I think it's a good mind job.
All right, on veto, recall that in 14 days. What date? All right, Norma Untello, bring that back on the Untello. Bring that back on the later in the week of, well, no, I'm sorry, make this December 1st as well.
At 30 days. Sometimes they have no time. Also 30 days. Then.
Defense and state. If y'all can review that and tell me if there are any objection.
Okay. What are you?
Oh, this one's done.
It doesn't cut out. Found guilty by. 99 years. Not more than 99 years. Not less. Oh, I'm not sure.
Why are we coming in the next day?
May I, Your Honor?
Yes.
Good morning. How are you doing?
Right.
I was trying to clean up, Wednesday. I have a hearing in Hondo. And
Okay.
it's gonna take all morning.
All right. So you want to come in on Thursday?
Thursday, please.
All right, sure. All right, we'll see you on
Do
Thursday.
you want my client here on Wednesday, or is he okay to come in with me?
No,
on
he can
Thursday?
come in on Thursday.
Thank you very much, Judge.
You're welcome.
Yes, sir. Okay, I'll get a hold of you. Thank you all very much for your consideration.
You're welcome. Bye-bye. All right, have parties had a chance to review the charge?
I need a few more minutes, please, Joe.
All right, thank you. Who's here on Joshua Carroll?
I'm here.
Yes, what is happening with this case and why is Mr. Carroll not here?
That's all, that's my fault, Judge. She was set November 3rd. That case got reset and I missed when I got the email from Roland that said the case has been reset, and you were doing something else. And I didn't see at the bottom of the email where it gave the new date.
All
So you'll remember Mr. Carroll, he's adamant he'll be here early. You'll remember,
Yes,
So
All right.
that's on me.
okay. So Ms. Ferguson, I need this brought back this week. When are we coming back?
Whenever you tell us to.
Are you able to come in
Let
tomorrow?
me look and see, Judge, if I. Can we do later in the week? Tomorrow's my daughter's birthday, so I'm gonna try to spend some time with her.
Happy birthday.
Thank you.
The 16th.
Okay, the 16th.
All right, we'll be back on November 16th.
Thank you.
Okay,
I hope I have the next one on. I think I might be the next one on your list as well, or file. No, no.
who's here on Janelius crew?
Oh, it's fine.
And is he in custody? All right, so we'll have to wait till he's brought out. So you're gonna have to come back this afternoon.
Okay, what time?
2.
Two, okay, thank
Your Honor, I've completed reviewing the.
All right, we're on the record. Is there any objection from the state to the charge?
No, Judge.
Defense, any objection?
No objections to the punishment charge, Your Honor.
All right, let's bring the jurors back out then. And defense, how much time are you asking for closing? Can I have one more printout?
I have one other girl that I conferred on and we're not able to reach a. Marcus is still doing discovery on it. Amber Grant. She's present.
All right, Ms. Grant, come forward.
Amber.
All right, last time we were here, there was a discovery involving a third party. That's what I have in the court's notes.
Right, Marcus is still, I just spoke to Mark wherever he went. He's still getting trying to get the online application forms that we discussed.
All right, Ms. Ferguson, can you call this for the second week of December?
Like the 12th, 13th, 14th in there, that's fine.
I think it's-
12th is fine.
All right, December 12th, we'll see you then.
All right, thank you.
All right, so they're still, okay, all right, no problem. We'll wait then.
Gunner, may I approach on Curtis Williams?
Just one moment.
Talk to that. Thank you. Thank you.
Brenda, do you see what page Amber Grant is on? Found it. Yes. All right, Curtis Williams.
Gunner, that's where we said, just to look into some things.
Well, the state has filed a dismissal. Okay,
Yeah,
case
we got
re-indicted.
Reindicted.
All right, and is your client in custody or on bond?
He's on bond.
Oh, come forward. Okay, and you guys keep passing that line. Brenda, there's a line and people just go around it. All right, yes, what is happening?
Just requesting a reset to look into some things. The last time the file wasn't here, because it was getting indicted. This is the first time we really had to confer on the case.
All right, Ms. Briggs, can I have a 1 month reset, please? All right, we'll be back on December 16th.
Thank you, Your Honor.
You're welcome. And Caroline, can you make sure these files stay together?
I don't know what the visitation is. No.
Yes, could I see the file on Williams?
So you need to wait or come back?
Yes, if you could wait for a moment. Vivian Ingo. All right, where are we on this case?
I'm not sure exactly who the letter is from. There's a letter from a counselor that you had requested last time.
Yes,
So as far as the setting itself today, Judge, I think that the state wanted time to confer with the complaining witness and her father.
yes.
At the last setting, I had filed a motion to remove the no contact order where the CPS caseworker appeared on Zoom.
Yes,
We got a letter from her and the counselor, and I believe that you, just to feel comfortable, you wanted a letter from the counselor stating that she didn't have any fear about the daughter going back to live with her mother. Well, I have that letter now, and I can offer that as defense exhibit 1.
oh, well, I mean, just 1 moment. Because we're not on the record yet. I'm just trying to see where we are, and I do remember this. All right, in state, have you had a chance to speak to your complainant?
Judge, we have not. We actually had an in-person meeting set up for Thursday, but with the trial turning into a jury trial, we had to reschedule for later this week.
All right, so when is that going to be? When is
I
that to take
don't
place?
have a confirmed date yet. I'll be sure to talk to them this week.
Okay, so just give us a moment. We're going to see when they're able to speak to their complainant this week. Then we'll have a date.
And then as far as the no contact order,
I need to wait yet, yes,
for that, okay.
yes, but they're telling me it's going to be done this week,
This
so
week,
just
okay.
if you can hang around a little bit,
I can,
so I can find out the exact date,
okay.
and that way you'll know, and then I'll make my ruling.
Thank you, Judge.
You're welcome. Robert Trevino, Caitlin Martinez.
Robert Martinez is here too.
All right,
He's walking up.
all right, so who's? This is the one
Yes,
here.
This is my client,
Okay,
Robert Trevino.
okay, just 1 moment. I'll give you. I said Caitlin Martinez, but Robert Trevino came up, and since you're here. Oh, but I don't have the file for Robert Trevino.
Oh, but I-
Caroline, do you have the file on Robert Trevino?
Yeah.
Oh, sorry, my fault. Here it is. All right, what is happening with Robert Trevino today? I think it's the plea deadline date.
And we don't have a plea agreement, Judge.
Okay, so you're rejecting the offer?
Yes.
All right, state, I need an acknowledgement of discovery.
Yes, Judge.
All right. And Ms. Ferguson, can I have a jury trial date for Mr. Trevino? How long do you expect this trial to last, Mr. Navy?
Say maybe 2 to 3 days.
January 9th.
All right, we'll come back on January 9th. Mr. Trevino, your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes, ma'am.
All right, thank you. Thank you for dressing appropriately for court.
Thank you, ma'am.
You're welcome. All right, who's here on Caitlin Martinez? Yes. All right, what is happening with this case?
We were last here on October 18th. And that time and the time before that, the DA was trying to unravel some of the evidence to determine exactly what contraband this defendant may have had possession of.
All right, and where are we on that?
I don't see the prosecutor that I've been dealing with, Judge.
All right, so we're gonna come back at 2.
Okay.
All right, thank you.
Thank you.
And that'll be it too. Damon Lloyd. Oh, at 2? Okay, that's 2. This one, we're gonna come back at 2 on that. And this one's at 2. Defense, how much time do you need for your closing argument?
10 minutes will be fine, Your Honor.
All right, thank you. Brenda, I didn't anticipate the charge being ready this quickly. So. Yes, I took them 12:30.
And Judge, if I can circle back on Vivian Mill,
Yes.
if we could recall it for this Thursday, the state's going to meet with the complaining witness on Wednesday.
All right. Can I see the file on Ingo? And so we'll come back on Thursday.
Thank you, Judge.
All right, thank you. Your patience is appreciated, Mr. Bailey.
Right.
And everyone, just give me a short break. And you can meet us. All right, everyone, please be seated. All right, ladies and gentlemen, I'm going to read to you the charge of the court as it relates to punishment in this case. Again, you will be given a copy of this back with you when you begin your deliberation. Charge of the court on punishment. Members of the jury, the defendant Mario Morales has been found guilty by you of the offense of continuous sexual abuse of a young child. It is necessary that the jury assess the punishment for this offense. You are instructed that the punishment for the offense of continuous sexual abuse of a young child is imprisonment in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 25 years. In addition to imprisonment, you may assess a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict. If there is any evidence before you that the defendant may have previously committed offenses or acts of misconduct other than that for which you have convicted him, you are instructed that this evidence, if any, was admitted to assist you, if it does, in determining what sentence is appropriate in the case at hand. You may consider that evidence in assessing punishment only if you first believe beyond a reasonable doubt that the defendant committed such other offense or act of misconduct, if any. In the event you have a reasonable doubt as to whether any other such offense or act of misconduct was committed, or as to whether the defendant was involved in such other offense or act of misconduct, then you will wholly disregard the evidence, if any, which may relate to any such matter. You are instructed that the defendant may testify in his own behalf if he chooses to do so, but if he elects not to do so, that fact cannot be taken by you as a circumstance against him or prejudice him in any way. The defendant has elected not to testify in this punishment phase of trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it in consideration for any purpose whatsoever. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to fix the same by lot, chance, any system of averages, or any other method than by a full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. Under the law applicable in this case, the defendant is not eligible for parole. Suitable forms are attached for your verdict if you should care to use the same. However, such forms are not intended to influence you in any way in arriving at your verdict. In any event, your verdict must be unanimous in writing and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and attached are suitable verdict forms. State, are you prepared to proceed with your closing?
Reserve its time.
All right, defense?
When you're a believer in the jury system, I am, and I'll come back with a guilty verdict. You made the perfect verdict based on the evidence here today. Now we're going to punish. Not going to be a big show about this. My client and your verdict, 25 years and 99, which gives you 65 possibilities. Legislature sets up these ranges of punishment because they realize that not every action is as horrible as that same kind of action again. And so it makes people like me to look to see, like, was the little girl maimed? She was a body part, arm or something. She confined to a wheelchair, or is she able to sit here in court and listen to this today and walk in and out? That's what y'all need to decide. What is appropriate for my client today, Bexar County, this court, this case. Thank you.
Right, state?
Like Mr. Hyde said, at this point, you're going to be able to determine the punishment appropriate. If no one is so, we'll just do that with. First, just to address the easiest thing, which is fine. This money doesn't go to the victim, to the state. Nobody cares what we specify. So if that's what the hang up is, you know how. Okay? And so really, what we have to here to determine what is the appropriate number of years this person could serve in prison, anywhere from between 25 years to 99 years for life in prison. So there's some things, again, the charge already tells you you can consider. You can consider all of the evidence from the guilt, innocence portion of trial, which is what you heard last week on Wednesday and Thursday. And so included in that is him previously convicted as a sex offender and previously going to prison for violation of the sex offender registration. And then you can also consider the testimony that you heard here today, but was quit from seeing. I know the defense wants to say, well, she can walk in here. But not all injuries are visible. Not all injuries to this child, whether the relationship she had afterwards, you're not gonna be able to see it when she walked in and out of court. She's gonna carry this baggage with her for the rest of her life. It's going to affect every single relationship that she's in. And you have to consider that. I think also the most important thing you have to consider is the fact that he's been previously convicted too. I know I made a lot of emphasis, but I think the question you have to ask yourself is, when would I be comfortable allowing him around my children? When would I be comfortable allowing him around my grandchildren? What number will prevent him from ever hurting a child again? I think the answer is easy. The answer is tough. Because absent that, he's going to continue to do the same things he has. And what's also concerning about this violation of sex offender registration is even if he does get off, does make it out of prison, who's to say where we can find him? Because he's violated it at least twice by his own admission. He's been to prison for it. This is not somebody we should ever have in our life. This is somebody we should never fall out around. This is somebody that I wouldn't ever want around my nieces, my nephews, strangers. So with that, I don't ask for this lightly. I really do. But the only thing that can keep our community safe is to send him away for a number in a year that we know he can't hurt another child again. That's why. So I'm asking that you go back and do your deliberation. This is a serious matter. I understand. I don't ask for this lightly. But I'm asking and begging you to assess punishment like in this case is again. It's what our community deserves. And that's the most important thing. That's what the state is.
All right, ladies and gentlemen, you now have the court's permission to deliberate. The deputy will take you back to the jury room. All right, everyone, please rise for the jurors.
You're gonna have the right to appeal. I'm not sure why we're doing that.
Oh, please be seated. All right, everyone, please be seated. Ladies and gentlemen, it's the court understanding is that you've reached a verdict on punishment. Is that correct? And is it unanimous? All right, if you could hand the form to the deputy, please. All right, Mr. Morales, if you could please rise. I'm sorry, just one moment. Can I have parties approach? Yes. All right, ladies and gentlemen, the court is in receipt of your punishment verdict. However, without objection from the defense or the state, you failed to enter anything for number 2. And I don't know if it's your intention to leave number 2 blank or not, but I'm going to send you back to the jury room for number 2. You've answered number 1, but not number 2. Does everyone understand? All right. If everyone please rise for the jury. All right, everyone, please be seated. All right, ladies and gentlemen, it's the court understanding is that you reached a verdict as to punishment. Is that correct? And is it unanimous?
Yes.
All right, deputy, if you could hand me the verdict form, please. Thank you, Deputy Mejia. All right, will the defendant please rise? The verdict reads, we assessed his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of life, and there's to be no fine. Does anyone wish to have the jury polled?
State is out.
We do not wish, defendant does not ask for polling.
All right, thank you. Please be seated. All right, ladies and gentlemen, thank you so much for your service. I'm going to send you back to the jury room and I'll be back there shortly, okay? All right, everyone, please rise for the jurors. All right, Mr. Morales, the court is going to follow the verdict that the jury has imposed. So the court will sentence you to life in prison with no fine. There's to be chapter 62 registration. And the court is going to order no contact with minors. Is there anything else from either side with regards to sentencing, state or defense?
Nothing to say, there is no vacancy.
Nothing further to think, Your Honor.
All right, Mr. Morales, the court has in its possession the document entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? All right, this was not a plea bargain case. This is a jury trial. So you do have a right to an appeal. Do you understand? All right, is there anything else before the court goes off the record?
No, Your Honor.
No, Your Honor.
All right, thank you. And we'll be back.